Today, me and my partner would like to explain about discharge by contract and remedies. This is my partner, hifdzul Malik, and myself, Nurnadhirah Safiah.
Now, I would like to share about discharge of contract. So, a discharge of contract happens when parties to the contract are released from any obligation arises under the contract. In other words, parties to the contract are no longer obligated to do as agreed under the contract. Now, I would like to share about discharge of contract. So, a discharge of contract happens when parties to the contract are released from any obligation arises under the contract. In other words, parties to the contract are no longer obligated to do as agreed under the contract. So, there are 4 types of discharge of contract, which is performance, agreement, breach, and frustration. First, we start with a discharge of performance. So, a discharge of performance is the most common way to discharge the contract. A contract will be discharged when the parties to the contract has performed what they have agreed to do in contract. The performance of an obligation must be done strictly in accordance with the terms of the contract, unless otherwise was agreed. So as example, for the law case, we can see in the case of Carter versus Powell. At that case, the court was rejected the claims of remuneration from the plaintiff, and plaintiff passed away 2 weeks before the voyage ended. The parties to a contract must be prepared to perform their respective obligation at the time and place stipulated in the contract. As example, time of performance, place of performance, reciprocal promises, contingent contract, tender of performance, personal performance, and joint agreements. Next, we move to the discharge of agreement. Discharge of agreement when the parties to the contract agree under free consent to discharge obligation from the former contract. The contract can be discharged if the parties agree that the contract will be discharged. This type of discharge is applicable under Section 63 and Section 64 of the Contract Act 1950. Section 63 provides that the parties can agree either substitute an existing contract with a new one, or rescind the original contract, or maybe alter the original contract. The application of the suspension of performance provided under Section 64 under the following situation, such as a payment of a lesser sum to satisfy the whole debts, or maybe an agreement for the settlement of debts between a debtor and his creditors. The next one is discharge of breach. Discharge of breach is when a party is in breach of contract. The other party of the contract has right to rescind the contract and claim damage from the breach. A breach may occur because of refusal to perform and disability to perform. So, what is refusal to perform and disability to perform? Refusal to perform is where one party informs the other by conduct or words that he does not want to go on with the contract. Disability to perform is if one of the parties is able to perform, the contract is breached. If the disability is because of something beyond the control of the parties, then it does not amount to a breach of contract, but is discharged through the frustration. For the law case, we can see in the Cho Yin Law versus Visuvalingam Pillai. For the case, the court allows a contract to be rescinded when an employer fails to pay wages once in every 2 weeks as promised. A breach may be expressly or impliedly from one's product. A breach can either be an anticipatory breach or actual breach. For the anticipatory breach occurs where one party indicates before the time of the performance, while actual breach occurs when performance is due on or in the course of performance. The effect from the actual breach is that where the innocent party terminates the contract, he must restore or return any benefits received from the parties. However, the party who is not in breach contract can continue with the contract and claim damage or repudiate the contract. For the last one is discharge of frustration. A contract is terminated if the things that parties agreed to do is impossible to perform. In order for contract to be frustrated, the following qualification must be satisfied. The first one is the event that caused the frustration must not be self-introduced. Second one is the performance of the contract must have been impossible and not merely more difficult or more expensive. And the third one is the frustrating event has substantially prevented the performance of contract as whole. As example, we can see in the law case of a tailor with cold well. So, the plaintiff hired the defendant's hall for the purpose of performing concert, but the hall accidentally burned down before the concert. For the hell, the contract was discharged by the frustration. Next is circumstance in which contract may be discharged by frustration. First is destruction of subject matter of contract. Second is supervening event defeat the whole purpose or object of the contract. Next is a death or personal incapacity. Next one is supervening illegality, and the last one is a declaration of war. For the last is the effect of discharge by impossibility. When a contract becomes void for frustration, Section 66 of Contract Act 1950 provides that any person who has received any advantages under it is bound to restore or compensate the person from whom the advantage was received.
Next, we go to remedies. Remedies is a general term which means a right that can be claimed by a party in the contract that experienced losses because of the other party in the contract was in breach. Remedies has 4 types, which is damages, specific performance, injunction, and quantum merit. Let's go into the first remedies, which is damages. Damages is the person in contract who did not receive the right that he should from the contract. The aim of damages is to reward losses and damages to innocent party because of the other party's breach, but not to punish the party who is in breach. A person to claim damages must prove that the losses incurred is expected by both parties because of the breach. Damages might be specific or unspecific amount, depends on the term agreed. Specific amount damages is the amount that has already been agreed by both parties when the contract is made. We have 3 categories of unspecific amount damages. First is substantial. Substantial is pecuniary compensation to put the plaintiff in a position he would have enjoyed had the contract been performed. Second is nominal. Nominal is a small reward to plaintiff after he shows that there is a breach of contract even there is no actual losses incurred. Third is exemplary. Exemplary is a sum reward which is greater than the actual pecuniary loss suffered by plaintiff, given only in exceptional cases. For example, case in damages is Hartley versus Big Sandal. When Hartley machine is broke and then he decided to make Big Sandal to make a contract to repair his machine and send it back as soon as possible, and Big Sandal is agreed. After that, the return back of machine is laid that Max Hartley cannot operate his factory and incurred losses. Hartley then wanted to sue Saddle and claim damages, but his claim was rejected because the court said there is no specific time given in contract and both parties do not expect the incurred losses. Second remedies is specific performance. Specific performance, it is an order by court to parties in contract to perform as contracted. It depends on situation where the contractual obligation is a trust, actual damage cannot be ascertained, or a breach cannot be adequately relieved by compensation of money. For example, is case Dunkirk versus Albrecht. The court ordered for specific performance on agreement for the sale of railway shares, which were limited in number and not usually open in market. Third is injunction. Injunction is discretionary given by court under Section 50. Injunction may be mandatory or interlocutory. Interlocutory injunction is used by a party to maintain status quo of a subject matter in a pending suit. Mandatory injunction is a court order requiring something to be done. Injunction may be also informed or restraining order or stopping from being done. For example, divorced parents, the one who do not get the child custody, restrained from meet the child because of some reason. Lastly is quantum merit, a claim that can be made by plaintiff who has performed obligation in a contract and choose to rescind the contract after defendant's breach. Court will order a value that is adequate. That is all from us. Thank you.